Hello and welcome into New York's Asset Protection Roundtable, a three pillars of protection program. I am Ben George. He's Ted Alatsis, attorney and counselor at law at the Alatsis Law Firm. Got another great estate planning show today as we talk about your questions. What's on your mind? We open up the mailbag, get a few of those today. Ted, how are you?
I'm doing great, Ben. How are you? Summer's here, and we're getting there.
I know. I know you and your wife like to travel a lot. Any big plans this summer?
Yeah, we've got a trip planned to the homeland, Greece. So we're
Right.
looking forward to that for a little bit.
Very good. I was going to ask you, as we kind of get into this, I got the legalese of the day. We'll throw your way here in a second. But if you had to live one place that you visited or traveled to before the rest of your life, would it be Greece or would you pick somewhere else?
Ooh, that's a tough question. I think it depends on the time of year that I go. I mean, I love Hawaii. It's fabulous. We've gone there a few times, and I could certainly see myself retiring there. That's one choice. I love the Bahamas. It's very and Greece is fabulous too. So it's a very tough thing. I always I believe I could probably live anywhere as long as it's not cold all the time.
Right.
So yeah, I think it depends on my mood.
Fair enough. All right. Well, we got a good show for you today. Again, if you have questions for us, alatsaslawfirm.com is the best place to start. But you can always call 718-233-2903. All right. We always like to do this from time to time, the legalese of the day, something you might have heard or a term that you aren't too familiar with that we want to try to explain here, or something that might pop up that we want to give you a heads up on. So our legalese of the day today, Ted, is conservatorship or guardianship. What is this?
Okay, so conservatorship or guardianship it's a legal process that involves the essentially the appointment of a third party to manage the affairs of the person who is alleged to be either incapable or incompetent or underage. So envision the scenario where person doesn't have any kind of estate planning, any trust planning, any power of attorney or anything like that, and now they've suffered a traumatic brain injury or something that requires or that impairs them to the extent that they can't manage their own affairs. In a scenario like that, having not appointed anyone, there's no one who has legal authority to manage that person's affairs. So someone applies to the court, usually a family member, to be appointed guardian or conservator. New York, we use guardianship now. They've gotten rid of the conservatorship language, but it's essentially the same thing. And it requires a couple of doctors to sign off and say that the person who is alleged to be incapacitated is incapable of managing their affairs. There's typically a hearing that takes place, and after sufficient proof, a person or persons are appointed guardian over both the person and the property. So that delegates that person with legal authority to act on financial matters as well as personal matters, depending on which of the two, or if or both, if they're appointed in that way. So it's a legal process that essentially appoints a power of attorney for someone. That's probably the most simple way to describe it.
Yeah, easiest way to break it down. I think this has been most talked about recently with Britney Spears, right? Because she was, I guess her father had her in a conservatorship, right, as well, and she was trying to get out of that.
Right. So another form of incapacity under the law would be not being of the right age, right? So she was, they were appointed her guardian, when she was minor, when she was young, and so they managed her legal affairs and her contracts and things of that nature. But after multiple years, that guardianship continued because she had other issues, right? So ultimately speaking, she went into court and challenged the guardianship and said, basically, I don't need a guardian anymore, and demonstrated to the court. And eventually, she won her, for lack of a better word, her freedom. So that's a scenario where guardianship exists as a matter coming from someone who's underage and has lots of assets to manage.
All right, very good. Thank you for that explanation. All right, it's time to move into our mailbag. As we always do, we like to answer your questions that come in, some scenarios that have played out within the office there at Alassis Law Firm, or other types of scenarios that pop up. We want to try to answer them here, maybe help you, provide a little inspiration, or hopefully just maybe clear up a little confusion you might have with your own situation. So let's start off today with Emma, who says, my husband and I are young. If either of us died early, it is very likely the other would get remarried. I don't want to restrict our ability to use our money, but also want to make sure that our children end up with everything and not our future second spouse. So how do you strike that balance? Do we have any options?
Emma, that is a great question. And, during our workshops that are held semi-monthly, we talk about scenarios just like this. This is a perfect scenario for what we describe as trust planning. Okay. And, in your, trust plan, you can certainly provide for, certain restrictions to inhibit the ability for, second spouses to have access to the funds that you are leaving for your children, while at the same time allowing for your current spouse, who survives you, to have access to income, principal, subject to certain minor restrictions. We go through the scenario where we describe the scenario where mom and dad have planned their estates, and they each have separate trusts, and dad has passed, and mom is the beneficiary of the trust, and mom, she can't manage the pool at the house, so she hires Biff, the pool boy, who's renowned in the community because he wears his Speedo everywhere and has six-pack abs. And after a while, he invites mom to go to the Bahamas with her and asks her to bring $10,000 so they can go. And mom asks her daughter, who's the trustee of dad's trust, for the money. And, she describes that she can't get any of the money because dad's trust said that as long as mom is using the money for anything else, she can. But if she was going to use it for cohabiting with another man, even for 24 hours, she wasn't going to get any of the money. And mom was okay with that, even though she was initially annoyed, because her trust said the same thing about dad, right? So her rule book restricted access to the money for purposes relating to second spouses, third parties who they hadn't envisioned, but protected everything for the kids and still had an ability to have access for her. So that you can do that in your estate planning documents and be very specific, or very general, but you could certainly put enough restrictions, enough protections, so that the money wouldn't be lost to someone who you didn't necessarily want the money to get lost to.
Yes, it's a scenario I hadn't really thought about, but it makes a ton of sense why that would be something that comes up quite a bit that you deal with. But again, not on my radar at all, but very interesting how that gets worked out.
Mm-hmm.
All right, thanks for that, Emma. We appreciate it. If you have questions you want to follow up with Ted on, you can always do so at 718-233-2903. All right, Edward has our next question. Our son has special needs and will require full-time care for his life. We're already setting up a special needs trust to leave money for him, but who takes care of him? Where does he live? Is there anything else we can do to make sure he's provided for after we're gone?
That's a great question, Edward, and certainly a real problem these days. As more and more children are diagnosed with various forms of the autism spectrum or other disabilities that are becoming much more commonplace for one reason or another. This type of consideration is important. So the first major step you've taken there is great in terms of setting up a special needs trust. But, at the end of the day, it's important, to set up a scenario where your son is taken care of by someone who you trust, right? So if your son is under the age of 18, certainly you'd want to, make sure you designate an appropriate guardian to take care of him. Most of the times people defer to a family member, but if it's not a family member, or you don't have a family member who you necessarily would think is appropriate, maybe some form of friends and or committee of friends who could certainly take care of your son. So it's a very important concern. Certainly, whoever you would select has to be capable of handling the various needs that your son may have. Right. So that's important. Another consideration is, do you have a home, and is your home part of the estate or part of the assets that you have? And, is your intention that your son be able to continue to reside in the home, and how would the home be provided for? How would the home be maintained? what sources of income would be used to maintain those things. So lots of considerations are needed to be addressed, and certainly some sort of extensive trust planning would go a long way to provide for a lot of that.
Edward, a great question, and we appreciate you reaching out and wish you the best. Again, if you want to follow up with Ted, you can do so at alatsaslawfirm.com. All right, we got one more question for you, Ted. This one comes in from Turner. A beneficiary of mine is older than I am. So if I died before them, I want to leave money for them to use. However, I would like to hold on to whatever they don't end up needing. Is there any way to do that once the check is written to them? Is it too late?
So Turner, yeah, that's a great question. Obviously, anytime you have a disposition and a check is written to someone, it will be too late to do anything about it. Now, that doesn't mean you have to, do it in the scenario you just described, right? So, the thing that we certainly recommend, and this is why, trusts are a great asset or a great tool in estate planning, is that, that you can provide for that person to have access to funds subject to the terms of whatever trust you provide, and then whatever's left and whatever other assets you have can be disposed of upon that person's demise, and not have the scenario where you've lost complete control by giving it to them outright. And there are other consequences too to giving people things outright. I mean, certainly once you've made a disposition, you've given something to someone, they can save, spend, give it away, do whatever they want with it. So if they're they've got bad credit, or they've got lawsuits against them, or they owe the IRS or anything like that, it can be lost to them too. So lots of different things you can do with a trust that would not only protect the asset, but give them the access to the asset as they need it or as you specified, and then whatever is left can go to other people how you see fit. So, certainly trust planning is by far the best scenario for you in a situation like this.
It seems like, just kind of hearing you talk, Ted, through not only this episode, past episodes, that trust planning just is the answer for a lot of people, right? It just gives them more control over what they want to try to do.
Yeah, I think it's not just the control. I mean, control is certainly a big part of it. But you also avoid probate. You also avoid challenges in court. You're able to make your estate much more efficient for your beneficiaries as well. So there's a lot of benefits to a trust. I mean, certainly I we do wills too, and we have people that will is probably sufficient for. But I would say the vast majority of the people who come to see us are much better off in planning their estate through some form of trust, whether it's revocable, irrevocable, completed gift, whatever it is. But most people are better off with some sort of trust plan.
All right, very good. Thanks for that question, Turner. And Edward and Emma, we appreciate your feedback and your interest today on the podcast. If you have questions for us, you can send them in at alatsaslawfirm.com or call 718-233-2903. And Ted, for anyone that hasn't started the estate plan and is thinking about doing so, and logs onto the website and goes ahead and schedules a consultation with you, which you can do right there on the front. You'll see the big blue button on the front of the website. What's their first step? What do they need to have ready when they come to meet with you for the first time?
Well, so when a client reaches out to us and they want to schedule a consultation, the first important thing they need to do is fill out our personal information form, which they can get on our website, or once they've scheduled a consultation, we would provide them, or they would fill it out when they come in. And it's really a summary of who your beneficiaries are, who your family is, what your assets are, how are they titled, what it is objectively in your mind you're thinking about doing with your estate. And then have an open mind to discuss the different scenarios that are available to you, so that you can make the right decisions for yourself. That's the key, right? So be organized, be intentional with what your purpose is in planning your estate, and be open-minded to listening to different ideas.
Well, if you're ready to create an estate plan that gives you peace of mind, you can also get on right now. Request that free consultation with Ted and his team at Alatsa's Law Firm and start that today. Ted, I appreciate it as always. Thanks for answering our questions, and wish you a good week, and we'll talk to you soon.
Same to you, Ben, and talk to you soon.